Feels weird.
talking.
I don't know. Yeah.
There we go.
Welcome to the Estates Made Simple podcast. My name's Gordon Vanderleek, and my co-host is here with me today, Jenna Carvello. How are you doing today, Jenna?
I'm good. I'm good. Thanks, Gordon.
We are on a mission. We wanted to start this podcast because we wanted to simplify the whole kind of the world of estate administration. We've both been involved with that, and we wanted to share our thoughts on making simple that which is complex, or help to explain it, and giving all the executors the right tools to make good decisions and to do their job as in administering estates. So thank you for joining us. A little bit about ourselves. I'm a wills and estates lawyer here in Calgary. I have my own firm, Vanderleek Law, and we focus in on the areas of wills, estates, and trusts. We do a lot of work also in the area of guardianship and trusteeship, and helping families that have children with long-term disabilities. And yeah, I've been practicing in this area for quite a number of years, and this has been a good opportunity to, I guess, put the record button on some conversations on matters that are important for executors. So thank you for joining, Jenna. Maybe a few minutes to introduce yourself.
Yeah, thanks, Gordon. So I am the owner of Guardian Estate Company, and we specialize in helping executors and any type of fiduciary through the stages that they need to go through by hiring professionals and guiding them to the right solution to suit their needs. Prior to Guardian Estate Company, I was with a major trust company for over 10 years, acting as a professional executor and trustee. So I've seen the benefits of proper planning, and I've also seen the drawbacks of when you don't plan properly. So as I mentioned last podcast, I'm really passionate about this, and I'm excited to talk about an exciting topic with you today, Gordon.
Yeah, indeed. And just before we jump into that, of course, we're going to try to provide some information, but what's appropriate for your situation, if you're the executor of an estate, is dependent upon all the circumstances of your case. So we encourage you to get legal advice, other professional advice from people like Jenna regarding your roles and responsibilities. So we're providing information only, and not creating a professional relationship, but we hope that it's helpful for people. Yeah, and as you say, a big question for people is, what do we do with these documents once we sign them?
Mm-hmm. Yeah, that's so true. So there's three documents that lots of individuals have in their whole estate plan. At the very least, I should say. There's the will, the power of attorney document, and then the personal directive. And each one governs a different type of role that the appointed representative will take. So once you've signed these documents, where do you store them in case you die or you lose capacity? So that's a topic that I think gets overlooked in some cases. You know, some people just shove it in their drawer, and some people put it in a high security vault. And which is the right answer? So we're here to talk about that today.
Yeah, and you bring up a good point that there's almost a different consideration for each situation, right? So there's what happens if you become incapacitated and somebody needs to access your power of attorney or your personal directive. And if you don't know where those are, you may be forced to go to court to get a guardianship or trusteeship order, which having your own documents in place is supposed to avoid all that, right? So just not having the original may actually create a problem. An example of that is if you have to put your power of attorney and send it to land titles to deal with the property, they only accept an original. They're not going to take a notarial copy or a photocopy. You know it to be the last one, but they go, no, we want an original. You can't find the original, off to court you go, right? And the costs associated and delays associated with that could be significant. So you're absolutely right. It seems almost a little trivial. Like, what do you mean? Where is it located? How can that be that important? But it's the consequences associated with that that can translate into delays and costs that we wanted to chat about today. The other reaction, or I guess fact to put on the table as we start our conversation, is I think the background for the will side of it, if we're looking at it from when somebody passes away and in the world of estate administration, will be there's typically only one original will. Every now and then, if I'm meeting with clients, I'll get them to sign more than one. Usually it's because there's a property in a foreign jurisdiction and they only accept an original. So there may be some advantages of having an extra original copy around, but generally more than one original would create a problem. In contrast, for a power of attorney or a personal directive, I think most lawyers will do more than one, right? There might be 2 or 3 or 4 of those because, as we've said, they have to be passed around to different places. So having extra copies, if you lose one, you still usually have 1 or 2 more. I typically do 3 copies, and it also allows them to put them in different places for safekeeping. Maybe one's in the house and one's in the safety deposit box or off-site, right? So what happens if the house burns down, and all those sorts of things. But the problem with the will is there's usually only one. And the other concept I want to put on the table right at the beginning, because I think it's important to understand and frame this issue, is if you can't find the original, because the original is required for the probate process. We talked about that in the last episode. So one of the rules through the probate process is you have to submit the original will. Even with the digital process, you scan and upload the original will signed by the applicant on the backside, but you got to ship the original to Edmonton, right? So somebody's still going to be holding on to that original. And so if you can't find it, the presumption in law is that it's revoked, right? So then the law says, well, if we can't find it, it means the person didn't want it to be applicable anymore. They ripped it up and threw it away. That's what it means. So now you're faced with, if you're going to go, no, mom passed away, but we can't find the original, but we have a copy of mom's will. Now you have to lead evidence to overcome this presumption that it's revoked, which is a big deal, right? If it's like if you die without a will, it means the prior will might be applicable or you die intestate. So while, and we'll talk about that, there's circumstances where you could submit a copy. The surrogate rules do allow you to submit a copy to the courts. You got to get over this evidentiary problem of, can you prove, in my example, it was mom's last will? How do you disprove that she didn't mean it to be revoked, right? So the court will accept that evidence, but you got to run out and get it. You got to figure that out, and yeah, that could, number one, lead to some delays. Like, just you got to search and you got to find that that information. And if you want to move quickly on the estate, right, then you're faced with, well, people are looking for the original and you don't have it. So there's an immediate delay.
Yeah, which could all be avoided if you stored your documents in the right place for your situation. And that brings to mind an estate that I was involved in the past, where a family member came to us looking for help in administering her parents' estate. And she didn't know where the original will was. But we had an inkling it was in the safety deposit box. But unfortunately, nobody had the key, and the bank wouldn't allow us to access it without the authority to go into the box. So that was a struggle, because on one hand, you need to go inside to get the authority. On the other hand, you can't go inside.
It's a chicken and egg, isn't it?
Exactly, yeah. And meanwhile, the estate held assets in marketable securities, and unfortunately the markets were fluctuating. And so, as you mentioned, that immediate delay, it could be sometimes very, very costly to the estate. If we had the original will, then the investment accounts could have been sold to preserve the value of the estate. So that just highlights the importance of ensuring that the documents are stored correctly.
Yeah, and you can't even get started on that process of going to probate and getting the necessary legal authority until you verified where is the original, because you can't just say, oh, I can't find it, and you spend a half an hour. Like, you have to prove to the court you've actually done a thorough and exhaustive search, right? And there's all sorts of other issues that are going on. It's just one more problem that could be there. What have you seen, Jenna, that there's I guess a trend or where people might in the past in your experience have left their documents?
Yeah, I think there's a couple of main options that they pursue. One is with their executor, whether that's a family member, a friend, or a professional executor. Between those two options, I would say the professional executor would be a better suited storage location. The other is at their lawyer's office, the one who drafted the will. I've also found some wills in freezers, or or in safety deposit boxes, whether that's at a bank or in somebody's home. But I think the most important thing is that the executor or the attorney, whoever's appointed, needs to know where to get the documents and how to get the documents.
It's funny you bring up the freezer story because I think if somebody has a firefighter in their family, they inevitably, that'll come out going, yeah, my son or daughter is a firefighter, says, put it in the freezer. I remember the first time I heard that a number of years ago. I go, what? Like, what do you mean the freezer? But apparently the freezer, according to firefighting professionals, is the last place if the house is going to burn down. Then things may be safe in the freezer. But yeah, it brings a smile to our face to saying you would put your important legal documents in the freezer. But I guess a thief may not look to think to go into the freezer to steal valuables. They're looking for a safe or other safe place. But yeah, I certainly have had clients who have said, that's where I store it. So I guess my response to that would be there isn't a right or wrong, which maybe seems like a bit of a vague answer, but for that person, if that works for them, then it works. We can find it. Hopefully it's in a vacuum sealed bag and there's not freezer burn on the important legal documents, making it, not capable of being read or destroying the ink on the paper. But it kind of a funny example, but it illustrates the point of, well, for that person, I remember when they said, no, I keep it in the freezer, and they were serious. But it made sense for them, so I'm not going to tell them it's wrong.
Mhm.
And everybody knows where it is. On that, and arguably it addresses the issue of what if the house burns down and the legal document goes with it. There was a number of years ago, I had a client who approached me, and I forget the location in the city of Calgary, but there was a condo complex that just went completely up in flames. Your memory may be better than mine on the name of that complex or the year it was, but I remember the person came in and the call was, I have to come in and redo my will because my condo burned down. And the will was in the condo and it was leveled down to the ground. Like it was a huge fire that just completely leveled the whole complex. Very significant fire, and everything was lost. Now, again, there would have been evidence that they didn't intend that to be revoked, but there's a real practical problem, and we got him in and said, well, he wanted to do basically the same thing. He did few little changes, but sometimes I get involved to help draft and put a will in place to solve the problem of we can't find the will, right?
Mhm.
And so, yeah, knowing where it is, to your point of the executor needs to know. They don't need to know what's in the document. You don't necessarily have to share the document with them because maybe you want to keep that confidential. But certainly the first thing would be, where is the will? Put another way, when somebody comes to me to go through the probate process, we're booking a first appointment, I'm saying, well, here's a list of things I need. Top of the list is bring in the original will. So it's the very first question I'm going to ask somebody to, in terms of going through the legal process. And if they don't have the answer to that question, that's an immediate problem, right? I can't even give them advice about who the beneficiaries are. Do they even have the authority? Do we know that they're named in the will? Are they just relying on a verbal representation of what somebody did? So it's an immediate problem to proceed, because how do I even know they're the right person that can give me instructions about how to proceed on legal matters, if I don't even know if they're named in the will, right? Maybe they thought they were, but what if the person changed their mind and didn't tell them, right? So having some communication with the family, I think, is important in from an estate planning perspective, is important advice. But on the practical consideration of where do you store your documents, that becomes important as well. The other thing I thought that to layer on top of what you said earlier, Jenna, would be, I think a lot of people think, oh, I'm giving it to the lawyer.
Yeah.
But just to put out there that the advice that is coming to lawyers in the province of Alberta is you should be getting out of the business of holding original documents. That wasn't always the case. I think traditionally the lawyer was seen as a safe place. It's offsite. The lawyer is the one that's going to need it. So why do we have the lawyer keep it? Because that's what they need. That's question number one, right? Where's the original will? Well, if I know it's in my filing cabinet, well, then I've answered that first question right away. It's very convenient. We can move straight into the issues associated with administering the estate. We're not dealing with that first question of where's the will? What happened to it? But the problem is that I think lawyers are being encouraged to get out of the business, which sort of makes sense, right? Because number one, what happens if a lawyer retires or becomes disabled or passes away? The lawyer is supposed to have a plan for any documents, original documents that they are holding on behalf of a client. But what if the lawyer doesn't do a good job of managing that? Ultimately, the Law Society will get involved, and they have a whole room filled with lawyers who are no longer practicing, but held on to original wills. Or sometimes the lawyer's executor is wondering, what do I do with all these documents, right?
Yeah, well, and if I could just jump in and share a story of that. So I think it changes if it's a sole practitioner versus a big law firm. A big law firm probably has better procedures and standards in place and how to transition the files from one lawyer to another. But I was involved in a state where it was a sole practitioner who drafted the will. The original was kept with that individual. He had retired. And then his book of business went to another lawyer who then later passed away. And we ended up having to search the house of the deceased lawyer's widow, who had no more capacity, to try to find this original document. And it delayed everything, just because the storage location was probably not appropriate for the case. So it was just funny that you bring that up.
Yeah. Well, and to the extent executors are keeping track of their hours and seeking reimbursement for their time and effort on a real practical basis, you're adding to the cost of the estate. So that's less for your loved ones that you're leaving your estate to, because you're giving more work to the executor. So in my case, I still from time to time will, if it's appropriate for the client to hold on to the original, but I think lawyers are starting to get out of the game. That's point number one. The other option would be safety deposit box, but I don't know if you've had some experience when you were doing the estate administration, but what I've seen is hearing from clients that it just takes multiple trips to the bank to get into the safety deposit box. And you alluded to that earlier. It's a bit of a chicken and egg problem. They go, well, prove you're the executor. We need a notarial copy of the will or the original will. Well, it's in the safety deposit box. Well, we can't let you in until you prove you're the right person, right? So, I think eventually those problems get solved. But one that comes to mind would be, I think client said it took 4 meetings with the bank manager to get into the safety deposit box. So they eventually got in, but oh my goodness, what a waste of time and a lot of stress. Because as you say, there's a lot of things to do right at the very beginning. And we can't get the original. We got to plan a funeral or a celebration of life. We got to start figuring out the assets that are there. We got to talk to the financial institutions and talk to the accountant and lawyer, and everybody wants this document and you can't find it. So it's adding a lot of time. And then of course you can leave it at home, and if you have a safe place, but then there's always, okay, what if the place burns down or it gets misplaced, right? And what happens in that case? Or sometimes, as you said, if it's offsite, right? I'm going to leave it to the executor. The problem there is that now you may lose a little bit of confidentiality. Like you're trusting somebody else to keep it as safe as you would want it to keep it. Well, what if they have it lying around, or somebody there, you give it to a kid and then a grandkid is rifling through the filing cabinet. Well, now they're reading your will. Well, that's not necessarily palatable. We got to go, okay, there's a problem with that. So there is this tension between wanting it in a safe place maintaining your confidentiality. So you gotta, I think, have a conversation with what makes sense. But I think the overarching theme would be, number one, it's important to know where it is, more important than people may think initially. And hopefully we've given some examples where that can create some issues. I think really communication is make a decision, but then make sure your executor knows what that is, right? And you know for each other, right? And then and I think there's a benefit of working with a professional, again, a bit biased maybe in that regard, because at least then the lawyer has the copy.
Yeah.
I've had a number of cases over the years where people go, yeah, I remember they did their own will and like they read it to me. So I know it existed. The person talked about, yeah, I did my will, but then nobody can find it. And now they're searching all over the place to try to find that one will. There was one case in particular that I think it took over a year. They were convinced the will was there. They went to every lawyer in the area. They went to the Canadian Bar Association. They went to the Law Society. They put notices in the paper. They were talking to whoever to say, where did this person put their will? Never did find it. But they knew it existed. And how frustrating was that, right? Because the results were significantly different versus, whether he had a will, because they understood what his intent was, but they couldn't find the legal document to carry it out. So then if he passes away on intestacy, it could be very different beneficiaries.
Yeah.
And other additional applications to the court. It was just a real mess because he did it himself and then he put it in a very safe place, but no one ever found it.
Oh, that's so disheartening, isn't it? And I see some of the changes that are happening in the legal community, and specifically in BC, where they're adopting people having the ability to write electronic wills.
Yes.
Do you think that's going to come to Alberta, and do you think that'll solve all of our issues with respect to document storage?
I think the answer, my guess is that we're heading down that road. We're able to do remote signings in Alberta, but not electronic wills. So the difference would be that you're signing electronically. It's not a piece of paper that's scanned in and stored somewhere. So where we could have somebody over a webcam, we can view somebody signing and they can see us signing with a witness. So with the 2 witness requirements, this would be that it could be done digitally, right? And stored digitally, which in first blush, you would say, well, doesn't that solve the problem if I just know it's in this folder in the cloud? But that, as you can imagine, probably has its own host of problems. In terms of the reading I've done and chatting with lawyers in BC, there's still lots of wrinkles in it. And it's not maybe the panacea to say, well, this is solving all the problems. And in BC, I don't think many lawyers are actually doing the electronic wills, because how do you keep it safe? How do you prove it wasn't changed or altered afterwards? The tried and true method of, pen and paper, it works. We know it works. We know what the rules are and we can rely on that, versus we got to try something really new. Oftentimes lawyers are wanting to rely on what they know to be certain, right? So we rely on precedent and this is what the law is, as opposed to what the law should be. So I think we're going down that path. The fact that we have a province in Canada, insofar as BC, actually adopting electronic wills and having those rules means I think it's going to trickle into the other provinces. I think they got to come up with certainly systems to make it usable so that professionals have confidence in the system. But I think over time, we'll get more confidence and more rules and more certainty, right? So, because we're never going to advise a path which creates uncertainty for our clients. We want certainty and a known result. So I think we are going down that route, and that may solve the problem for some people, but we're a ways away from saying, no, I could do my will on DocuSign. And there's still the need for a meeting and getting together, right?
Yeah.
Which is funny when you look at lawyers advertising or on their websites. I should check, maybe I even have it on mine. It's like the fountain pen with the fancy paper, right? I mean, that's sort of what everybody thinks of with the will, because there is an element of saying there's a formality, right? There's a stated intent that this is what I want to have happen to my property when I'm no longer here, either disabled or on death. So knowing where that important legal document is, because it's your final wish, right? That's what we talk. Your last will um, is really important. You want to make sure your intentions get carried out. So that starts with finding a safe place and making sure the executor knows where that is.
Yeah, I think that's the perfect summary to our discussion today. We should pick this conversation up in 5 or 10 years to see where the whole world of electronic signings and estate planning
Yes,
is.
that
But
that is a whole other, that can be a whole other topic. And I
yeah,
think if that we are watching with great interest some of the developments in BC and say, how does it impact this area? But if you as a listener um, can't answer the question is of where is your will, then I would encourage you to take some action to either find it or say, well, maybe we need to redo it. This is a good excuse to say, let's redo our will, because we did it in Edmonton, and we moved from Edmonton to Calgary, and now I don't even know that lawyer. I don't know where it is. So if that applies to you, maybe this is a podcast episode that will help you solve what could be a big problem. So yeah, thanks, Jenna, for sharing your experiences, because that's, I think, sending the signal that this is a real problem. If you don't do this well, it could create a problem, but it is a problem that is avoidable.
definitely. Well,
Yeah,
thanks, Gordon.
thank you.
Next episode, we'll be talking about common executor mistakes. So feel free to listen in. Thanks, everyone.
Bye now.